In October 2024, we gathered at the PASI Legislative Summit to tackle a profound and troubling question. Why do our judicial systems seemingly disregard the Constitution, leading to the fracturing of families? The issue of parental alienation has evolved into a silent epidemic, often manipulating as a powerful weapon during divorce disputes. This manipulation not only harms the relationships between parents and their children, but also inflicts emotional and psychological turmoil on the children themselves. As policymakers engage in lengthy discussions about shared parenting arrangements, child support formulas, and custody regulations, the true victims, our children, are often left on the sidelines. They face the emotional fallout of these contentious debates while their lives are dissected as if they were mere bargaining chips in legal negotiations. It is imperative that we come together as a community to advocate for the meaningful change in our family courts. We must unite to ensure that the voices of children are prioritized, fostering environments where they can thrive rather than endure the negative ramifications of adult conflicts. Their well-being should always take precedence, driving us to demand legal reforms that uphold their rights, dignity, and emotional health. Only by standing together can we hope to create a future where children are shielded from unnecessary strife and their best interests at the forefront of every decision made.
Also with me is Julie Grayson, an attorney who's the executive director of the Family Preservation Alliance and a nationally recognized legislative advocate on family and criminal law reform, testifying in hearings throughout the United States. Julie sits on numerous local, national, and international committees regarding constitutional rights and court reform. She is also a court-appointed special advocate for children. She produced and co-hosted a podcast on CF Digital, The Voice of Contemporary Family, a broadcast service of Preserving Family Ties Media on child welfare. Please welcome Julie.
Joey, I'm going to try and test.
And Joan reading Brian.
Okay, so Brian Ludmer unfortunately had an emergency, cannot attend. He had a letter that he had written from a conversation he and I had had. The conversation kind of started as me waking up in the middle of the night going, wait a minute, can the legislators really ban the term parental alienation and the type of treatment? Isn't this a HIPAA violation or a cutting off of services? Isn't this a violation of our rights to choose our own medical care? From that conversation, Brian and I talked, and he wrote up, this is the summary of it. The letter, a physical letter with his citations is in the Google Drive. So the key points are judicial recognition of protective separation, that, we've got to separate this there from, you can't merge medical and allow the legislator to have control over medical like this. So the letter states that protective separations are evidence-based and judicially recognized remedies of last resort of conflictual family situations. The Ontario Court of Appeal decision in AMC versus CH validated the use of such remedies despite objections. This is important. The court indicated that healthcare consent legislation does not conflict with these remedies as they are psychoeducational and not treatment-based. This is referring to our reunification programs that they keep opposing. Caden's Law critique. The letter, Brian's letter questions the constitutionality of Caden's Law, which assumes that these interventions are harmful. Ludmer argues that courts frequently order such remedies because they are not harmful and merely challenge pre-existing views. That's important. They're saying, hey, no, this isn't an issue. We use these. Why is it all of a sudden that because it's part of a court case, we can't use it, basically? Or why is Caden's Law dictating medical at all? Healthcare consent legislation. The Ontario legislation requires procedures to be potentially harmful to trigger a child's consent. Since the interventions are psychoeducational and not classified as harmful, the healthcare consent rules do not apply. evidence-based science versus legislative interference. Ludmer expresses concern about legislative attempts like Caden's law to limit remedies that courts have successfully deployed for many years. The letter emphasizes the need to focus on long-term outcomes of children who go through these interventions. Reality is, reality is that these remedies are actually used when we are debunking cults, such as religious cults. It's pretty much the same type of treatment. So if you're going to tell me we can't use it for parental alienation, then we can't use it for religious cults or, you know, anything related to like Stockholm syndrome or Patty Hearst syndrome. Advocacy for unification therapy is framed as non-harmful outpatient remedy to resolve parent-child conflicts, particularly in alienation cases. The letter argues that courts routinely apply this remedy and it should not be restricted based on misconceptions about harm. Upcoming discussions. The letter notes concerns will be discussed at the legislative conference hosted by blah, blah, blah. We don't need that. Final remarks, invites comments from his recipients and suggests using the Ontario courts rules that they've been using, basically. This letter is on the Google Drive. Please make sure to access it. I can put the summary out there, but I don't know if you guys really need that. I am now turning this over to Miss Julie. And let me take this down. No, you need it for. So we're over here. Let me close that. Let me blow this up. Okay.
Well, first I wanted to thank everybody for having me and for really hanging in this long. This has been a long day. Everybody's presentations were so constructive to help and helpful in many different academic disciplines. And I really wanted to speak about parents' rights, constitutional rights, and the goal of what we're really trying to do here today, which is draft legislation that is efficient, effective, and do it in a way where we're prioritizing bills according to what can move the needle the most. I did want to, in context, just put a generic statement out there. This community is in a public health emergency. It not only affects the psychological, but it leads to the physical. I know so many colleagues, targeted parents, people in the community who have gotten physically ill from this kind of work. And I really want to applaud everybody in this room for being here and having the tenacity and strength to continue on with these goals. In Colorado, there is something called Amendment H as in Harry, which is now on the November ballot. The reason why I bring it up is I think it's a really important piece of legislation that everybody in this new room should prioritize and know about and replicate in their jurisdictions. It is the judicial discipline, procedures and confidentiality proposed amendment to the Colorado Constitution. What it is doing in summary is it's creating an independent board of people who can oversee the judges, whether it's an ethical misconduct or whether they are just missing the point as to what's going on in our community. And it's not judges policing judges. you file an ethics complaint with the judicial board. It is an independent board. I hope everybody in Colorado votes yes to it. I think it will really move the needle because the two main things in our community that we face as a problem is accountability and transparency. If we do not have those two things, then targeted parents and children will still be disenfranchised. The next thing I wanted to talk about, just to add some context to an issue called absolute immunity, is there is a case I'm sure many of you are aware of. For those who are not, it is Stump, S-T-U-M-P, versus Starkman, S-T-A-R-K-A-M, K-M-A-N. It's a 1978 case. And the Supreme Court, it deals with judicial immunity. Judges have absolute immunity. Politicians don't, police officers don't. And this was an Indiana case where a judge was sued by a young woman who was sterilized without knowledge as a minor, as per court order. So she couldn't have children unless she adopted or fostered kids. She felt the need to take it all the way, and it did go to Supreme Court. The Supreme Court held that a judge will not be deprived of immunity because he took an action. Didn't matter whether it was an error, didn't matter whether it was done maliciously or with any nefarious intent, unless it falls within a very narrow window of beyond his job as a judicial officer. And the reason why I bring that up is because that set the standard that is still current today. If you do not have accountability, if you do not have transparency, and you run the risk of judges policing judges, certain other committees policing their own, and the only way around it, this law, which I do not believe will change. When I was in law school, I remember my constitutional law professor pretty much scaring us, letting us know about the power of judges and the absolute immunity they have. And the only way that I see a bill being introduced is something along the lines of Amendment H in Colorado. So I really hope whatever you feel individually or collectively is a priority for a bill. I hope you will add this to your list. The next thing that I wanted to talk about is parents' rights. There is overlap with some constitutional law. And if you are a targeted parent, you cannot effectively advocate to the best of your ability in the best interests of your children unless you have an arsenal of information that could lead to, let's say, recusing a judge. And I'll talk about that later, but you know, that you'll get another judge that might be briefed by that judge. And so it becomes a rat on a wheel and a vicious cycle. But I did want to make you aware of violations of constitutional rights. Violation of the Fifth Amendment is the first one. It's a due process clause that assumes guilt before proven innocent when allegations of abuse are made. Second one is violation of the 14th Amendment due process clause, which could be substantive as well as procedural. And I could talk to you individually about the differences in the interest of time between the procedural aspect and the substance of the 14th Amendment. That due process clause protects the fundamental rights of parents to direct the care, upbringing, and education of their children. And then something I'm very passionate about is the First Amendment, which is very interesting because I look at it in terms of two categories. One is enumerated rights that are actually enumerated. Others are called unenumerated rights. And within the unenumerated rights is the right to parent. In terms of my legislative advocacy, which I am passionate about, I look at cases in terms of three buckets. The first bucket is early intervention, when these cases are about to go to the courts, be assigned to a judge and assigned for a case for first hearing. The second bucket, because we want to make sure that our entire community is protected, is the people who are in the throes of what we can all agree is a broken family court system. And then the third bucket, which the community unfortunately has gotten larger and larger, are the cases that aged out of the system. These cases are either because a child turns 18 and parents need relief, targeted parent and targeted children need relief, I should say, and also the special needs cases, which are becoming more and more apparent in the family court system. And you have to end up going from family court, can't take a breath, can't take a breather, and then you go to the guardianship court. And every state has different guardianship laws, different jurisdictions do it, like whole different process, but the emotional component of is the same. You are sucked into this vortex of dysfunction in the courts. So I'm a glasses half full person. I believe that we will solve these issues, and I believe legislation is the only way to tie the hands of a legislative, of the family court. I moved to Colorado about 14 months ago, had a place there part-time, but I'm there full-time now. I've been fortunate enough to work with some very competent advocates and professionals who are in this room right now, Colorado and in New Jersey, York, Connecticut, and other states. And I decided that at this stage in my career, I'm going to see if I can apply to the courts and work with judges. So I can see firsthand in this climate what is going on. Now, I can't divulge a lot of what I saw, but on a lark, I applied for a position working with judges who are overwhelmed in the Boulder County courts. And I saw exactly what was going on in the courts, and there is need for tremendous reform. I was very blessed to be primarily assigned to a judge whose name is Patrick Butler, and I'm throwing his name out there because he's a unicorn. And with the combined courts, I mostly did was in the courtroom for serious first-degree murderers, arsonists. There's a lot of overlap in parental issues that led to where they were handcuffed and shackled. And we were given protocols and procedures how to protect ourselves as court staff. And Judge Butler retired recently. And he recognized power and control dynamics. He recognized things. He's originally from Connecticut, by the way. And he is one of the rare people who understand the nuances of what everybody here has been speaking about. And so it was very helpful for me in that experience to be able to sit down, put pen to paper, and hopefully bang up some really good legislation with this group and other groups going forward. On the topic of judges, I wanted to say it's really important to know your judge or judges in your case. And I break this up into two categories. One are pro se litigants. It is, you have to look at your records. You have to look at the judge's records because the disciplines that professionals and competent mental health experts like Tina says is lawyers and judges are on the other side, trained very differently. And so if you have a judge whose record is bad when it comes to parental alienation or issues related to that, my advice to you is that it's critically important that you let the mental health professionals hash out the DSMs and everything else and put parental alienation in the diagnostic manual. But until that time comes, you have to talk in generic terms to the court as to what is going on. And so I just wanted to provide some synonyms for what we all know in this room, parental alienation is child abuse. But if you have those judges that don't see it and you know this in advance, I just wanted to give you a bunch of terms to use. And those are terms that could be used in bills. One is broken bonds between a parent and a child. Two is blocked access of parent to child. Three, you can go out on a limb and say gatekeeping or alienating behaviors of parents interfering with the relationship between parent and child. And for those of you that have counsel in your cases, they need to do their research on the judges that are involved in your case. I did also want to talk about a couple of things that I didn't see mentioned here today. There are federal bills that have been introduced. There is a bill in Washington, D.C. right now. I have worked with the general counsel for Senator Scott, who introduced a bill in January of 2024. It's called the Families' Rights and Responsibilities Act. And even though it says families, right? I think it's geared toward parents and helping targeted parents on the federal level. So his general counsel, Dave Kalin, was also at the meeting with me, and the health professionals. His general counsel asked for edits to that bill, which I did provide him. I had a second meeting with him, and Tim Scott was on the short list for potential vice president position. So that kind of fell by the wayside. But then when he was out of that, he's back in the game of, getting bills passed and doing what he needs to do for families. So you can Google it, S3571 on that. The other thing I want to talk about, I'm sorry, I'll wrap it up, but I wanted to let everybody know, I know we have an agenda here for specific bills, but I have a bunch of things with me. I have at least 17 bills draft that I've done, everybody else. For one, for anybody who needs it, I have Dave and I and others in New Jersey are working with a senator right now who wants to become the primary sponsor and drafting of the shared parenting bill. I have that in my hand for anybody who needs that right now to see if they agree with it, emulate it, and go forward. The other thing that we were doing, and this is jurisdiction specific, so you have to check your states, is the concept of introducing a joint resolution. That is a framework like the four walls of this room in a public policy statement that addresses the plethora of issues that we're dealing with in the broken systems and just introducing them. So generically, there is a framework going forward for a lot of bills that could come out of this. So I have that with me as well. I briefly wanted to let you know that I work with criminal law reform. What is going on? These are not family court cases. These are criminal law cases in my view. And so because of that, I brought in several jurisdictions the criminal statute for interference with custody. In Nebraska, they just revised it and they added in subsections, which is a lot easier to do than introducing random bills that talk specifically about the issues that are plaguing this community. I have that with me. I'm sorry, Jenny, I'll wrap up. I also have the kidnapping statutes. Make no mistake about it. When these cases go before the family court needs to stay all these cases. Stop it and punt it to the prosecutor. So I have that law with me here too. I have intellectual property. I worked with Colorado Resilience on this one. It is a high conflict, contested custody, early intervention and rapid resolution flowchart that I'm making available. I also have, thank you, Dave, for emailing me this. Our biggest opponent, in my view, is the American Bar Association. And as long as attorneys and others are making money hand over fist in this, and this is their red line, then I have the opposition letter that the American Bar Association wrote. So when we're in our committees, as Joni said before, I'd like half of you to oppose or whatever, because a pathological person can find a pinhole in a bill and slip through it, and we want to keep this tight. I have with me the advocacy wheel. At least 63 people, strangers in kids' lives that go through this, are introduced in the system. And that in and of itself creates adverse childhood experiences before we even get into all the things that Tina said. So I have that with me as well. Also have, want to make sure that I hit all those points. I want to talk about this for a second.
We don't have time. Julie.
Acknowledge Mr. Todd Bobo, who's an attorney in Colorado.
Right, I'm getting
He
to.
has experience in the family law system.
Todd, I want you to unmute yourself and so that you can speak. I promise if we have some extra time tomorrow, we can delve into some of this other stuff. We've just kind of run out of time. Todd, go for it. I hope we can hear you.
Yeah, can you hear me?
And let me just switch the view.
Julie, thank you.
Thank you, Julie. Oh, yeah, and thank you, Julie. I'm so sorry for this. Just.
Can you hear me? Hi, can you hear me? Took mute off. Can you hear me?
Okay, hang on.
Is that audio?
He's just got, we're just plugging in audio. Hang on, Todd.
Okay, Todd, go ahead.
All right, can you hear me?
No, he's not.
Which state is Todd in? Thank you.
And say that again. All right, Todd, are you able to, or is Clint doing something?
Yes, can you hear me?
He needs to say something so I can.
I,
Todd, you have to say testing.
testing, can you hear me now? Can you hear me now? Testing. Can you hear me now?
Todd, can you hear me?
Put the speaker.
I can hear you. Yes.
Here we go.
Go ahead.
Can you hear me? Okay, I just would like to add a few things. In Colorado, I was the access to justice. Can you hear me? Yeah, now you can hear me? Okay. I can't hear you, but I can just go ahead. I was the access to justice chair in the Arapahoe County up until last year, which is the busiest jurisdiction in Colorado. And the dream in the country is to have Gideon civil, which is have all litigants represented in civil court. In my experience, there's 76 to up to 90% of the litigants in family law are unrepresented. And I just saw them get annihilated in these kinds of parental alienation situations. So the one thing that I can add is the LLP program that was just approved by the Supreme Court. And I think the first 46 licensed paralegals are now able to represent litigants, which I think will be the biggest game changer in Colorado. I testified before the Supreme Court on that, and also the issues Julie talked about with Amendment H and the discipline for judges. But I could provide you more information. I think the most critical part for these litigants that are pro se is having somebody, anybody, even if it's a paralegal, to take the emotion out of it. I experienced that myself as an attorney for 17 years. I'd never been exposed to family law until I was in the midst of a very nasty divorce with a lawyer that's been going on 6 years. There's over 1,000 filings. The cost has surpassed $1 million. I pay anywhere from $10,000 to $30,000 a month. I have achieved 50-50 parenting, but the fight has not subsided at all. Anyways, this LLP program, I think, will be the best assistance to litigants, and it's starting to roll out in other states. It's in Arizona and Oregon, and it's primarily for family law, only for family law. There's certain things that they cannot do, such as cross-examining experts. But as far as these issues, I think it'll really help these unrepresented pay a fraction of the cost in order to defend themselves when these allegations come up. So looking forward to tomorrow. That's just what I would like to add. I can't hear you.
What I'm doing. Todd, can you hear me now?
Yes.
Okay. Do me a favor. Anything you've got that you feel we can use, email it to me. I will get it up on the Google Drive.
I definitely will.
That'll help because that's easier because then people can take it, read it, contact you if you want to put your contact in it. Everybody's contact info is out on the Google Drive. Does anybody have a question for Todd while I'm here?
Just connect us by email. Please.
Yeah, you have his stuff. It's in the Google Drive.
Oh, I can email. So I can reach out to you.
His contact is in the Google Drive in the contact list. There's a reason I don't have time to email everybody individually. Go ahead, Brian.
The question for Todd is, what does he think about judicial immunity?
Can you hear him? What do
Yeah.
you? Okay, good.
This was another topic that I was set to testify in front of the Supreme Court. I think we have some of the most corrupt judges in the country. We have the first Chief Justice that was disciplined. Amendment H, it's really interesting how what's going to happen with it, because it's judges policing judges, and they have complete immunity. And how do you defend against that? In my situation, all of the judges in the county recuse themselves. So these judges in family law are so incompetent. They have no training. And when I started to look into that and, find out what their training was and how they're coming to these decisions that are just so contrary to the law, it was just astounding. And, I was a paramedic for 10 years. So I tell people I used to drive ambulances. Now I chase them. I do mostly civil personal injury until I got into family law. I'm extremely passionate about it now. But the level of scrutiny that happens in family law is completely different of what happens with these insurance companies. They scrutinize every penny. And in family law, for example, we had a decision maker and his decision was supposed to be final. It was black and white, clear as day. My ex just filed anyway, and the judge granted her motion, and she's done that over and over. And so it's the scariest thing, judicial immunity, because unless they recuse themselves, I had one friend said, if you're going to kill the bear, you better kill the bear. If you maim the bear, you got a mad bear, and they're the ones that decide. And so I've experienced that firsthand. It's frightening. So we need more oversight and what to do about it.
We have the same problem here actually with attorneys, where they get a get out of jail card free. So I can't tell you how many attorneys have been brought up on the in front of the grievance panels. The grievance panels look at them and go, you got one of two choices. You either retire early or face the music. And what do you think they all do? Get out of jail card free. And that's a problem.
Yeah, I mean, there should be even our current chief judge right now. He was harassing these women at law firm. Then he went to be a DA. Same thing happened. So he applied to be a judge. It's the same thing that happened with our last chief judge. So they have no oversight, and they police themselves. It's frightening.
Larry, go ahead.
Control language. When you have no accountability and no transparency, that breeds corruption. I don't want you to think that you necessarily have corrupt judges. Any system has corrupt judges and give them this absolute power. I don't think it's the individuals that you just got bad apples. I think it's a systematic thing because people need accountability. Otherwise, absolute power corrupts. Absolutely.
Todd, you could hear that?
That's exactly right. And I have a friend that's a judge, and I ride bikes with him, and he would tell me I wanted every case to go my way, and he would tell me that the level of how he manipulated cases. And so it's happening, and it's rampant in Colorado. I think the most effective tool, I saw one litigant, really smart guy, that sued him in federal court. And it didn't survive. He lost on summary judgment or on a motion to dismiss. But getting those allegations out about what these judges are doing was highly effective. And this particular magistrate has stayed right there as a magistrate. He hasn't progressed up to county court or district court. So I think in a roundabout kind of way, his allegations, they work to a certain degree.
Sean, go ahead.
Todd, is there any constitutional argument that can be made to attack sovereign immunity for judges?
I've seen that happen in federal court, and I don't think there's a case where it has been successful. They have complete immunity. So not in these cases, not in family law, at least.
Is there anything at the legislative level that can disturb that in any way? I mean, if you take the case history of all the cases where judges have been found to act outside of the scope of extrajudicial, where I remember reading a bunch of case law where judges were held responsible for acts that they committed in a judicial capacity, but they were not acting in a judicial capacity, such as a judge who jailed somebody for a non-jailable offense, things of that nature. Can you take that existing case law and then go to the legislators and find an end run around to get a law that gets rid of or changes judicial immunity to qualified immunity?
I think to even get to that level, you have to have you need certain situations that you can point to why it's needed. And because of the transparency, you don't get to know when these judges are even disciplined. It's so secret right now, unless you know firsthand knowledge of it. You can't even get to that information, and that's the problem. So there's no end. There's no way to even go to the legislatures and show why this is needed. I don't think we've had successful discipline that's been public in like 36 years in Colorado for these issues, because they do just that. As soon as they know that they're in trouble, they resign. And
Is there a way, Todd, to get at the front end of this where you have litigants who do have a case that could be properly put into federal court to make a federal court claim, where you would keep pushing the issue, even if it gets dismissed on summary judgment, because sooner or later, one of them is going to survive, and we are going to nail a judge to the wall where they belong.
I have 2 cases here in Connecticut. Todd, are you going to stick around to do legislative tomorrow?
yes, and I'll upload those cases that have died. At least they were brought to federal court, but at least they.
Larry, you have something quick?
Yeah, just have a really good article breaking down judicial immunity and whether judges should be held immune from malicious. Really good article.
Send it to me.
I have to find it first.
One of the legislations we do want to work on is immunity. Here in Connecticut, their marshals had to escort a judge off of the bench because he was so arrogant. He was trying to throw a father in jail who was indigent. He insisted on throwing him in, and the court clerk said, you can't do that. He needs representation. He says, I don't care. Get me a public defender. Public defender says, no, he's got to apply, yada, yada. And the public defender refused. The judge says, well, then go get me a regular attorney. Regular attorney came in, says, no, I can't do it, blah, blah, blah. This judge was furious that he could not throw this father into jail. This also happened to a mother. 2 separate judges. They actually, Judge Visconti, I want to say his name is, the marshals were brought in and actually escorted him off of the bench because he was so out of control. So while it may not be coming up the way we want it, it is in little ways. Philip, go ahead. And then Carolyn, go ahead. And then we need to end so people can take a break.
Thanks, Todd, for appearing. Too bad he wasn't here in person.
Todd, we have virtual people that want to do legislation virtually. So if you stay on and you come back tomorrow, please, would you be willing to work with the people that want to work on legislation virtually?
Yes, absolutely.
Thank you. Carolyn, go ahead. Quiet, please.
I had to go back to the next 10 years as a sitting judge, and every time I didn't make a decision, he would take the whole appeal. So you shouldn't have to go back to the same judges. That's another problem.
Was that the judge that I testified in front of? Okay. Okay, I'm going to recap because you probably couldn't hear. Carolyn had a case where she kept having the same judge for 10 years, and she would appeal. And he would say, you don't like it? Appeal. She keep reappealing and reappealing and reappealing. And this should not be happening. We shouldn't have to keep appealing and appealing and appealing. And she won. Right.
Can you hear me?
Let me re-clarify. She wins the appeal and it goes back to the same judge who, of course, isn't going to do diddly squat. And then she has to appeal again. And the same thing happens again.
Well, I had 2 situations where we kept fighting. I had a judge that did that. It was in a civil case, and he came out so hot against us. It went up to the Supreme Court. We won, and 6 months later he resigned. So they're so temperamental when you attack them personally, and this guy didn't last. That happened with 2 judges.
So we've actually. Right, you shouldn't have to. We have gotten 2 judges removed here in Connecticut, but trust me, this took us decades to get them removed, and it was only because one of them had 3 people die under her care because she didn't listen at all, and the other one because violated something else. Okay, so look. Yes, Philip says thank you. I'm not sure if you heard him say that.
Thank you. Wonderful work you guys are doing. It's so exciting.